Good morning, everyone. We are so excited that you are able to join us for today's webinar. We are excited to be discussing hot topics in design law from the US, Japanese, Chinese, and Korean perspectives. I'm so thrilled to have with me today my fellow co-authors, Alexandra Bellick, Tomohiro Gito, and Guanyang Yo, who are going to discuss updates in the law in their respective jurisdictions. So to start us off, I just want to remind everyone how we got here, which is that myself and my co-authors wrote a book that was first published in September 2020. And in that book, we attempted to, and hopefully did, provide a comparison of design law within the 6 largest jurisdictions in the world. And in addition to a sort of country-by-country comparison, the book also includes an important set of chapters at the beginning, which provides a real nice overview of design law from a global perspective. That chapter was edited and reviewed by all of the authors, so hopefully it does represent a variety of views, but still provides a cohesive guide to design law around the world. We're also very excited that the book includes a comparative example case. In that case, we chose a blender, and we've provided that design in the styles of multiple different countries, so that hopefully you can get a chance to review that and really understand how the design drawings differ from country to country. Finally, we did a second update this past fall, and we're very excited in the update that we were able to provide additional statistics about filing of designs as well as enforcement of designs around the world. Again, we think that the purpose of the book is to help provide an overview of design law around the world for those who need to make decisions about filing as well as enforcement. We did a companion webinar earlier today that included updates from the EU and UK. That webinar was recorded, and we will be sending out a link to that webinar in addition to a link to the recording for this webinar. So now I'm going to turn things over to Guanyang, who's going to discuss some recent updates in Chinese design law.
Okay, thank you, Beth. So this is Guanyang Yao, and I am a patent attorney from Liu Shen Associates, and I'm from China. And I have been practicing patent law for over 18 years in China. And I focus on the patent and also the including design and also trade secret. We have been providing the legal service to quite a couple of big companies, and I'm mainly on the patent litigation side. So my service covers the field of design and engineering, software, telecommunications, and medical service, something like that. So I'm very happy to be here and to introduce some updates on the design system in China. Since there's a new amendment maybe 2 years ago, which becomes effective in June the 1st, 2021, yes. My presentation mainly includes 3 parts. So first, I will introduce some updates on the partial design. So because the partial designs are the new things in China, so I will give some introduction on the partial design and the current practice in China. And the second part is the GOI design. So there's a new judgment issued by IP specialized court in China. So we can see something from that judgment. And also I will introduce some trend in the design patent litigation in China. So I will start from the partial design. Actually, the patent law, the 4th amended patent law becomes effective since June the 1st, 2021. So in that amendment, the partial design has been officially incorporated into the patent system in China. So, but another thing is that there is a guideline for the examination. So there has been long discussion on such guideline for the examination on the partial design part. So it is still pending. It is still pending. So it has been 2 years after the incorporation of partial design, but the guideline for the examination is still pending. But we hope that it is in the list for the final approval by the standing committee of NPC. So we are expecting that the guideline for the examination and also the detailed regulations for such partial design will be issued in maybe within this year, but maybe before the end of this year. But we are still be waiting for such guidelines. However, a draft for such guideline has been issued last year. So that draft is seeking the public comments. Although it is a draft, but from our view, we believe that it is almost the final version. We believe it is almost very close to the final version. So from that draft, we get some general impression about the partial design practice in China from the CNIPs. They are holding a conservative attitude about such partial design because it is a completely new system in China. So actually, I believe that the examiners on the design department also are doing some research from the world view to see what should be holding by their hands to examine such partial design in China. So that's the reason why we believe that as a current practice or at the current stage, the whole attitude for such partial design would be a little bit conservative. And so we can see here is some non-eligible subject matter for partial designs. From the high-level concept, we can see that such the partial design should be at least a separable independent area or a relatively completely designed unit on the product. So if there's only a part of it, maybe something like only a flower on some surface, so maybe it cannot be cannot be protected as a partial design. So we can see that here is some, maybe we can jump to, so here are some ways of declaring or designating parts that to be protected. So how to show such partial designs in China. So here are 3 ways. One is the solid lines and combined with dotted lines. So we believe that this is the primary way. Although that is not a formal guideline, but we believe it is close to the final version. So such solid lines and dotted lines are also consistent with the international habit. So we believe that solid lines and dotted lines will be the primary manner to claim such partial design. And also a covering mode. So which means that you can see that the solid lines and dotted lines, so in the left of the pictures. So the covering mode in the middle, so we can see the covering parts are intended not for protection. And so, and another way is that the dot and dash mode. So this mode is using dot and dash lines to demarcate the part and the protection and from the other part. So here are some examples. You can see some examples. And we can also see that the how to give the name of such partial designs. So it should be connected with the whole product. So we can see some examples. So we can see that the seat back of a chair, and also the some camera of a cell phone. So it should be connected with the whole product. So and there are some voluntary amendment opportunities, and it is allowed to change the claim subject matters. For example, from the we can see we call that integral design or entire design to partial design, and also from partial design to entire design. So there's a 2-month window for such voluntary amendments. After this 2-month window, so there would not be any chance for such amendment. So, and we can see here are some views and requirements of the views to be submitted. And we can see that here is the views shall not only show clearly the partial design of the product that is intended to claim, but also review its position and proportion in the whole product. So we can see that why I call the attitude to be conservative, that means that there's really a partial design, but such partial design should be associated or should be combined with the whole product to be shown to the public. So, and if the claim part contains a 3D shape, so the submitted view should include the perspective view showing the part clearly. So we can see here's the car. So if we claim the protection for partial design for the bottom of the car, so we need to show clearly the bottom. And also here are some, there's not too many partial designs that have been granted. So we check the database and find some examples to show to you. So this is one example. So we can see that here the partial design is claimed using the solid line, and those dashed some circles on such product. So those dashed lines in each view are the parts that are not claimed to be protected by this design. So we can see that this dashed lines part is very, we believe it's not a big part in this product. And so we can see another example. So also, so here we can see a dashed holes here. And there's an abstract. So there should be an abstract in the design application to say that whether those dashed lines are claiming for partial design, or those solid lines are or this whole design application are claiming for partial design. So, and it should be clearly described that in each view, the dashed lines are the parts that are not claimed to be protected by this design. And we can see another example. This is a shoe, and we can see here is the lace of the shoe that is in the solid lines. And so this in this design pattern, and such shoelace is claiming for the partial design, and the solid lines show the parts that are claimed to be protected by such design, and the dashed lines and show the background. Those dashed lines is showing a shoe actually, but it's only a background, not to be protected. And also, we can see the sole of the shoe. So such sole of the shoe can also be protected. And so we can see here's some white translucent layer and also dash that are not to be protected by the partial design. And we can also see here that the priority claim. So it is the same with the original, we call that entire or integral design. So the draft guideline does not stipulate any specialty standard for such partial design. And so that is the partial design part. So actually, the time is running about maybe 10 minutes. So maybe I will give a very quick browse on the following content. So let me see, here's another topic, which is the GUI design. So it is really increasing because after it is officially accepted on May the 1st, 2014, so the amount is increasing. So some typical GUI designs. So we can see some GUI for the phones, also VR interface and AR interface and 3D software interface. So these are the mainstream GUI filings in China. And there's a dilemma actually for enforce such GUI design in China because that although it is GUI design, actually it can be called something equivalent to partial design. But when we enforce such GUI design pattern, and it should be considered together with the whole product. So that should be a dilemma that the entity to manufacture for such a whole product and not the entity to develop such, if the GUI is for app, so it's not the entity to develop the app. So the involvement for such physical carriers will surely increase the difficulties of the litigation. So there's a high-profile case in Shanghai court, and in this case, so the court finally decided that although so the apps although the infringing product should be the phone, it should be carried by the phone, and the infringing product should be the app, the design of the app. So there's no need to really involve the entity of the phones in the litigation. So the main liability of the case of the infringement should be on the developers of GUI apps. So here's one thing. And so another topic is the increase of damages in the infringement cases. So we can see that here's the punitive damages in China, and 1 to 5 times in the whole patent system. So actually it is generally for all the other IP fields, for example, if in the trademark field, so punitive damages has been incorporated many years ago. But for the patent system, it is incorporated only in this 4th Amendment of patent law. So the current practice is that the damages of design infringement cases has been increasing a lot. So we can see some high-profile case, and here's a Casio case. It's about a watch. So the final damage is awarded of the something like US dollars 1.2 million. So yeah, so we can see that the design is playing much important role in the whole design patent system in China. And so there's a lot of amendments and updates for design in China. So if there will be some further questions, so I'm very happy to answer those questions. So yeah, have that. So that's my part.
Great, thank you. And now we'll move on to updates from Korea. Alexandra, what can you tell us about what's going on in Korea?
Yes, thank you, Beth. So today for my presentation, I want to introduce some of the recent amendments that were brought to the Korean Design Protection Act. And after, I will quickly discuss about a recent landmark precedent that was rendered by the Korean Supreme Court. So let's start. So the first amendment that I want to discuss about today concerns related design. And before I get to the actual amendment, I thought it would be worthwhile to briefly review the concept of related design in Korean law, because there are not that many jurisdictions that have adopted a similar system. So basically, under Korean practice, when a given applicant files an application for similar design, and by similar design, I mean something like the design you can see on these slides. So actually, there's one design that it's like an animal character. Actually, this is a cosmetic packaging. And the other ones is furniture. And the last one, maybe it's a little bit difficult to see, but actually it's a bench with a roof. So in case of filing designs that have those kind of similarities, you would file one of the design as a principal design, and any variation of that principal design would be filed as a related design to that principal design. So with that short introduction in mind, just gonna move to the amendment. So under the Korean Design Protection Act, an application for the related design has to be filed within 1 year of the filing date of the application for the principal design. But for application that will be filed from December 21st of this year, the law has been extended to give 3 years instead of 1 year. Just one thing to keep in mind is that this will not apply if the principal design was filed prior to the entry into force of the amendment and more than a year has passed since the filing of this principal design at the time of applying for the related design. So this amendment was brought in because there was some requests by the industries that are relying on design registration to protect their design, because they felt that the 1 year period was somewhat short to protect modification to their existing designs. So this is good news for the concerned industries. So moving on, before I introduce the other amendments to the Design Protection Act, I'd like to just quickly briefly explain how the grace period for the exception of loss of novelty is calculated under Korean law, especially because this is an issue for which we often get questions from our clients. So when you look at these slides, maybe you think, oh my God, it looks really complicated, but actually it's quite simple. And so my understanding is that in the US and in Europe, if you file an application within the condition of the second example in this slide, you would be able to obtain a registration for your design without any problem. Basically, my understanding is that the grace period, regardless if it's 1 year or 6 months, it's calculated from the date of the priority filing date. And so if you file like this, you wouldn't have any problem. But in Korea, and really it's very important that I underline this point, the 1 year grace period to claim the exception to loss of novelty is calculated from the date of filing in South Korea. So if you file a design application within the condition of this second example, you wouldn't be able to obtain a design registration in Korea because at the time of filing the application in South Korea, more than a year would have passed since the date of first disclosure. So very important to keep in mind. So with that being said, under the current Design Protection Act, in fact, to claim this exception to the loss of novelty, there are a specified period of time during which the claim needs to be done. And this is when, at the time of filing the design application, or any time prior to the issuance of the Korean office final decision on whether to grant or reject the design registration. After that, the only 2 other times you will be able to claim it is in response to an opposition or an invalidation action. And so this is going to change from December 21st this year, and there will be no more time restriction. And the reason for that change is there had been a lot of criticism from a Korean practitioner because especially so once the design registration had been granted, there were situations where you could not claim and it was a problem, especially in the case of an infringement action. So to give you an example, if you're an owner of a design registration and you file an infringement action, and the defendant argues in defense that your design registration is invalid because it has a novelty issue, although you may be able to claim the exception to loss of novelty because the prior published design on which the defense is based, you could claim it's within this 1 year period. You wouldn't be able to do so within the context of the infringement action. So in order to work around this issue, currently, you need to artificially use a third party, file an invalidation action against your own design registration so that you're able to claim the exception to loss of novelty, and then in the infringement action, be able to argue against the defense argument. So luckily from December 21st this year, this will no longer be necessary, and it will be possible to also claim the exception to loss of novelty within the context of an infringement action. And the last amendment that I want to discuss today is regarding priority claims related procedure. Essentially, the goal of the amendment is to give more time for priority claim procedure. So the law provides that to claim a priority claim must be filed within 6 months from the filing date of the foreign application that serves the basis of the priority claim. But from December 21st, this 6-month period can be extended by 2 months if there's a justifiable reason. So the law does not give any example of what those justifiable reasons will be, but from the wording of the law, we know that it will be an idea more relaxed than an act of God. So we can imagine that probably if the applicant, for example, has been hospitalized, that probably you would qualify for this 2-month added 2-month period. So similarly, under the law, you need, in order to claim priority, you need to submit a copy of the foreign priority application within 3 months from the filing date of the design application in South Korea. So this deadline too will be able to be extended by 2 months, again, if there's a justifiable reason. And lastly, the amendment provides that the priority claim can be amended within or added within the 3 months from the filing date of the design application. So typically this could be used if you want to add maybe some of classes that you hadn't added initially in your priority claim request. So this is it for the amendment to the Design Protection Act. So as I mentioned, I want to introduce a recent precedent to the freedom to operate defense. Actually, the Supreme Court rendered earlier this year 2 decisions on this, but because the principle that was established by the court is the same in the 2 decisions, for the purpose of this presentation, I will just present one of these 2 decisions. So maybe first, I'll just explain what this defense is under the Korean practice, because there could be some differences depending on jurisdiction. So in Korea, the freedom to operate defense is one of the defense that is available to a party that is accused of design infringement, in which the defendant argues that it is free to use the design that is targeted by the infringement action, if this design is identical or similar, or it could have been easily created from design published prior to the date of filing of the registered design on which the infringement claim relies, and this regardless of similarity with the registered design. So in this case, this was regarding bed frames, and actually it's not an infringement action, it's a scope confirmation trial, and the freedom to operate defense also work in that context. Before I explain the decision, I'll explain what a scope confirmation trial is as well, because this is also not a type of action that is available in that many jurisdictions. So in Korea, any party can file a scope confirmation trial and ask whether a used design fall within the scope of protection of a registered design. And this type of action can be requested either by the owner of the registered design, but it could also be asked by the person using a design. And typically this type of action is filed before going through infringement action, because infringement action tends to be very costly, or in order, to find a settlement between the party. Maybe there was a cease and desist letter sent, something like that. So it's less costly and quite easy way to just determine the scope of protection of a given design registration. So in this case, the owner of the design registration had filed the scope confirmation trial, and in defense to the action, the defendant argued that its design, that he was free to use his design, so he argued the freedom to operate defense, because his design was similar to a prior published design of the owner of the design registration. And in parallel to this, the user of the adverse design filed an invalidation action against the design registration. So in response, in the invalidation action, the owner of the owner of the design registration argued that, so in the invalidation action, the owner of the design registration claimed the exception to loss of novelty, and it turned around, and in the scope confirmation trial, no, it's okay. In the scope confirmation trial, the owner of the design registration argued that the defendant could no longer rely on the freedom to operate defense, since it had claimed the exception to loss of novelty in relation to the prior disclosed design. So let me just turn to the slide. At the appeal court, the lower appeal court level, the Intellectual Property High Court, the argument of the petitioner were rejected, and the IP court said in its judgment that it would be unfair to bar the defendant from relying on the freedom to operate defense, despite the valid claim to the exception to loss of novelty, because the court found that the defendant would have trusted that there was an earlier version of the registered design that had already been disclosed to the public prior to the filing of the registered design. And so basically the IPI court thought that third parties, like the defendant, that were relying on this should be protected against infringement action. So the Supreme Court rejected this interpretation of the law and reversed the decision. And in its ruling, the Supreme Court considered that, in fact, the Design Protection Act provides certain conditions under which you can claim the exception to lack of novelty. So notably, you need to file the application within 1 year from the disclosure, and you should also submit a supporting document. Just one small note, like you will remember earlier in the presentation, I mentioned that the law will be amended and there will be no more restriction as to the timing of when you can request the exception to loss of novelty. But we don't think this will affect this ruling, because the general principle of this ruling still stand, because there are other conditions that a person asking for this exception to loss of novelty needs to follow in order to obtain this claim. So going back to the decision, the court also noted that third parties were sufficiently protected because the Act provides for basically a statutory non-exclusive license for parties that started to use their own design prior to the filing of the design registration, as long as it was done genuinely. Basically, they have no idea that there was another party that was creating and was about to file a design registration for a similar design. So in essence, the court found that the interest of both parties, the design registrant that can claim the exception of loss of novelty, and third party, that the rights of each party was sufficiently protected within as the law is currently written. So this is it for my presentation. I hope you enjoyed it, and if you have any question, don't hesitate to let me know later.
Thanks, Alexandra. That was really helpful. Okay, so now we're going to hear from Tomohiro, who's going to tell us about some new updates in Japan.
Okay. Hi, everyone. My name is Tomohiro Gyoda. I'm a patent and trademark attorney from SIGA International Patent Office in Japan. Today, I'd like to explain the grace period practice in Japan. The grace period practice will be revised. The JPO has not officially announced when the revision will become effective, but I think the revision will become effective in next year, in 2024. Today, I'd like to explain the current requirements for the grace period, and I also explain the revision. So these are major requirements for the grace period. First, it is necessary to file a Japanese design application within 12 months since the first disclosure date. Second, it is necessary to submit a statement for enjoying the grace period at the time of filing application. Third, it is necessary to submit certificates for proving disclosing acts within 30 days since the filing date in Japan. Fourth, a design should not be disclosed through IP publications, such as publication relating to invention, utility models, designs, or trademarks. If a design is published, disclosed through IP publications, the design cannot enjoy the grace period, even if the other requirements are met. And fifth, all disclosing acts must be proven. And this requirement will be revised. In the following slide, I'd like to explain each of the requirements except for requirement 4. A Japanese application must be filed within 12 months since the first disclosure date. It is not a priority application, but a Japanese application that must be filed within 12 months. Foreign applicants often misunderstand these requirements. So even if a priority application is filed within 12 months since the first disclosure date, it is still necessary to file a Japanese application within 12 months since the first disclosure date. I think that this requirement will be the same as that in South Korea. And Japanese application must contain the statement that the grace period should apply to the design. And it is not permitted to add a statement after filing. However, in the case of Hague international applications, it is possible to add the statement within 30 days since the international publication date. And it is necessary to submit certificates for proving disclosing acts within 30 days since filing the application in Japan. But this period cannot be extended. So this is a very tough requirement. And a certificate should indicate information on disclosure, including the date, the place or URL, the name of the disclosing party, and photos of the design. And no signature is required. Before 2020, it was necessary to sign a certificate. But concerning the COVID-19, the JPO rapidly amended the requirement, and currently no signature is required. However, it is necessary to indicate the name, and the title of a person who belongs to the applicant company and who is able to represent the applicant. It is indeed permitted to sign the certificate, but if a certificate is signed, the JPO would require you to submit the original. So you need to send us a hard copy. So we recommend submitting certificates without signature. And currently, all disclosing acts must be proven. I'd like to explain this requirement by using an example shown in this slide. First, an applicant disclosed a design of a smartphone at an exhibition on April 1st, 2022. Next, the applicant disclosed the same design on their official website on October 1st. Then the applicant posted information about the disclosure on October 1st on SNS. And finally, the applicant filed an application in Japan on April 1st, 2023. And in this case, in principle, all three disclosing acts must be proven. However, the post about disclosure on SNS is based on the disclosure on the official website. In Japan, a disclosing act that is based on a prior disclosing act does not need to be proven. So it is permitted to omit the disclosure on November 1st. So namely, it is necessary to prove all independent disclosing acts. So under the current practice, it is necessary to prove two disclosing acts, namely the first disclosing act on April 1st and the disclosing acts on October 1st. But as you might understand, a design is often disclosed many times, and it is sometimes very difficult to identify all the disclosing acts. So the JPO decided to relax this requirement. After the revision, only the first disclosing acts must be proven. So with this example, it is sufficient to prove the first disclosing act on April 1st. And you can omit the further disclosure on October 1st and November 1st. And if the examiner cites disclosing acts on October 1st or November 1st, it is sufficient to state that these disclosures were made by the applicant. And the first disclosing act is already proven. And then the rejection would be overcome by that argument. However, it is still necessary to submit certificates about the first disclosure within 30 days. Actually, I expected the JPO would relax the requirements. However, the JPO still maintains the other requirements. Especially, it is a hard work to prepare and submit certificates within 30 days. So comparing to the other jurisdictions, I think the grace period practice in Japan would be still strict. I hope that the JPO would more relax the requirement. Especially, I hope the requirement regarding 30 days would be removed in the future. And that's all. Thank you.
Thank you, Tomohiro. That was really interesting. So I am going to now give an update on U.S. design law and some of the things that have happened in the last couple of years. These are the things that I'm going to focus on, and for the sake of time, I'm going to jump right in. So finally, the United States is doing e-grant, or is doing electronic publication of patents. What you see there in the picture is actually what a U.S. patent looks like. That's the current cover page. They design it or redesign it fairly regularly. But up until this April, the U.S. Patent Office printed patents on paper. And now they are doing electronic publication, which we're very excited about. We think that from a design perspective, it's going to make the design rights that applicants get clearer and easier to read. It is still possible to get a paper patent, but you have to pay extra and you have to order it. This is also in conjunction with, I don't think it's actually in conjunction with, but the timing of it is such that the Patent Office, the U.S. Patent Office, is also rolling out a new public-facing system called Patent Center, which is supposed to be more stable and easier to use than the previous system. So here's some statistics regarding what's going on at the Patent Office, and I raise this because the United States continues to have a fairly long pendency. Like many of the other countries that we've discussed this morning, the United States is engaged in examination of design patents. Unfortunately, pendency has ticked up a little bit in the last 6 months or so, and it's now 17.8 months to getting your first office action. That might be a notice of allowance, but it also might not be. And the total pendency across the board is 20.9 months, because many patents do get a first action notice of allowance, but not all of them. One of the reasons that the pendency has ticked up is, and by pendency, you can see we have almost 80,000 design patent applications in the US that are waiting examination. And one of the reasons why the pendency has ticked up is because the US Patent Office has hired additional design examiners. They're now up to 303 design examiners, having hired a new group of, I think it's close to 80 in the last few months. And what happens when they hire a new group is initially the pendency ticks up because the existing examiners have to take time away from their docket to train the new examiners. And then once they're up, their training is more current, then then you see the pendency really kind of drop off as those new examiners come on board. And what we've heard from the Patent Office is that they're actually planning on doing another round of hiring sometime in the next year or so, which will hopefully mean that the pendency gets lower. Okay, I want to also discuss a couple of notable cases that have come out recently. One is the LKQ versus General Motors case, and this case is going to be heard by the complete appellate court in the United States. And this is important because that complete court has the power to actually change the law in a way that the normal 3-judge panels do not. And the question that the court is interested in hearing about is whether or not a U.S. Supreme Court case that came out in 2007 about utility patent obviousness, whether that opinion should have some bearing on design patent obviousness. So in the United States, in addition to clarity and definiteness requirements and novelty requirements, there is a requirement that design patents be non-obvious or not an obvious variant over prior designs. But this obviousness test is, we've had the same test since the early 80s, and the test is fairly well developed, and it requires that you have a primary reference and a secondary reference, and there are certain rules about how you determine whether something is a primary or a secondary reference. And so the test does have a number of steps to it, and the argument that LKQ is making is that test is too rigid under the guidance that was provided by the U.S. Supreme Court in the KSR case. And this could have some pretty big implications if the case does come down and changes the test for obviousness. And that's because every design patent that is enforced today in the United States was examined by the US Patent Office under the Rosen and Durling test. So if the Rosen and Durling test is eliminated or changed, that could have an impact on the obviousness analysis of every design patent that's enforced right now. My expectation would be that if the test was changed, this would mean that every time someone went to enforce a design patent, the issue of obviousness would be raised by the opponent, because that would make sense if the test had changed. So this is an important case. We expect it will be argued probably next year sometime, with the decision coming maybe at the end of next year. Okay, another case, and this is a case that actually has been argued to the same court, the Federal Circuit, and we're just waiting for a decision on this case. And this case has sort of two important pieces to it. The US infringement test for designs takes into account prior designs in terms of understanding the framework and the background of the particular type of designs of the products that you're considering. And and this was what was set up by the court in 2008 in the Egyptian goddess test, or goddess case. And the issue here is there was the discussion of background prior art appeared in Egyptian goddess, but the court did not exactly explain how to figure out what that was. And so one of the issues that came up in this Columbia case was, how do you figure out what prior art is relevant to the infringement determination? So we're hoping to get some clarity on that. And the other thing that's kind of interesting in this case has to do with the use of a logo, the accused infringer's logo on their product. So you can see in the picture here, the design that was at issue in this case is on the left, and the product design of the accused infringer is on the right. And the accused infringer has applied their logo. So this is not a counterfeiting case. It's not as if they were using someone else's logo. They applied their own logo to the product design. And the question is whether that logo can be taken into account when engaging in this question about whether or not the claim design and the accused product are substantially similar. One argument that the patent owner has made is, well, if you're allowed to just put your logo on an otherwise infringing design, then isn't that some sort of get out of jail free card to accused infringers? So we will see how that turns out. But this case could not only limit the scope of relevant prior art, but it also could be an important one for companies to consider if they are in a space where it's possible they might run afoul of someone else's design patents. Okay, another case that is important, and this is a little bit older case, but I do think it's really important, so that's why I've included it in the deck, and that is the In Re Surgisil case. And in the United States, prior to the In Re Surgisil case, the question for anticipation of a design was really focused on the visual appearance of the prior art. But in this case, as you can see, the design patent, the applied for design patent was on the left, and on the right is the prior art. And both the examiner at the patent office as well as the appeal board at the patent office both found that the prior art tool was anticipatory prior art to the lip implant, and so the lip implant shouldn't become a patent. But the makers of the lip implant, Surgisil, they further appealed this case to the Federal Circuit, and the Federal Circuit had a different take on it. What they did was look at the actual claim of the design patent. So this is a way in which the United States varies a little bit from many other jurisdictions around the world. Not only are you showing your design in images, but you're also making a claim like you would in a utility patent. And that claim is proscribed by the regulation. It's an ornamental design for in this case, lip implant, as shown and described. So what the Federal Circuit said was, well, you're claiming a lip implant, so that is narrowing the scope of your claims. We don't award designs in a vacuum. we award them and patent them as applied to a product. And so as a result, the Federal Circuit took the position that the prior art tool was not, kind of at all similar to the lip implant, so therefore could not be used as anticipatory prior art. The result of what we've been seeing is that applicants are very careful in how they select their claim and title, which in the United States, based on regulation, actually have to be the same thing. So really what you want to do is sort of thread the needle. You want to pick a claim or a title that will allow you to still enforce the patent, use it against whomever you think would be using your design, but you're not being so broad in your title as to perhaps bring in prior art that is not directed to the same. So that is an update on the most important things going on in the United States. I also just wanted to provide a brief update on filing in The Hague, because this is becoming, I think, it's an area of a lot of interest, and a lot of companies are looking at it closely to decide whether or not it might make sense for them as a company. So just as a review, the Hague system, like Madrid, is a administrative filing system. When a country joins The Hague, there are a few requirements, such as a minimum term that they have to include, but there's not really a lot of other substantive changes to their laws, if any, that they need to make. So what does that mean? That means that when you file a single international application with The Hague, with WIPO, or with your local patent office acting as an office of indirect filing, what happens is your single registration, or your single application, is farmed out to all of the different countries that you select. It's the same application goes to all of them. And then that application is examined or not, or registered based on the local laws of the member country. And by way of example, this can lead to some sort of interesting results. For example, under the terms of Hague, you can include up to 100 designs in your single international design application. And that's fine, and as long as they're in the same class, when you go to some place like the EU, for example, that will not be an issue. But when you bring that same application to the United States, you run into the issue that each US design patent can only have one design in it. Sometimes that's more than one embodiment, but it can still only be one patentable design. And so some applicants have the unfortunate situation where they file this multi-part international design application. When it comes to the United States, for example, it then needs to be split into many different applications, which is often an expense that the applicant didn't think was going to happen. So I think the message here is to make sure that you are considering the substantive rules of the countries that you're selecting, and you're not just getting excited and checking a bunch of boxes on the form, because that is going to end up possibly with some unintended consequences. But the Hague system has some features that you need to understand, but it has grown considerably. You can see in the last 9 years, the United States has joined, Canada, Brazil, Russia, China, Korea, Japan. I mean, it has just grown by leaps and bounds, and there's the expectation that many of the other major countries are thinking about changing their laws in such a way as to join the treaty. So it can be a powerful tool, but it's really important to make sure that you're getting quality advice from someone who has experience, or someone who has the ability to reach out to foreign counsel in the other countries you're thinking about applying to make sure that your single application is going to do what it is you want it to do. Okay. And with that, we have time for some questions. So if you are interested in asking a question, please type your question into the Q&A box, and we will attempt to answer as many questions as we can. So go ahead and ask those questions, but in the meantime, if any of the presenters have questions for each other, this might be a good time to ask them. Does anyone have a question then when they watched the other person's presentation that they thought was interesting and they were curious? I have a question for Guanyang then. Guanyang, I'm curious if there are not examination guidelines that have been issued. I have been getting office actions on partial designs from China. So how are, if the design guidelines haven't been issued in final, how is it that the Chinese Patent Office is able to examine those applications?
Yes, so that's a very good question. So although there's no formal guideline issued, but there's a draft. So before that draft, we observed that there's almost no partial design granted. So after that draft is issued, we see some partial designs have been issued. So we guess that draft could be a basis for the examiners to do the examination. So that also means that draft is very close to the final version. So maybe that the guideline will be issued at the end of this year. So that's our guess, only our guess. So we do not know the timetable. So that's all I can answer.
No, that's very helpful. Thank you. Okay, so we do have a couple questions in the Q&A box. This one's also about China. The question is, does the Chinese Patent Office perform substantive examination of the Hague application? So I think maybe, Guanyang, if you can answer sort of the first question is, does the Chinese Patent Office perform substantive examination of any applications, and then do they treat Hague applications any differently?
Generally, for the China Patent Office, there is no substantive examination for design application. But for the Hague application, actually I'm not very sure because I'm not completely on the application side, prosecution side. So from my general knowledge, so it seems that there would not be such substantive examination on the design application. So I believe that should be covering the Hague application. But I can check later so to make sure that whether there will be such substantive examination for the Hague application.
Okay, well that's interesting to know. Okay, so we have a question for the U.S., so I'll read it and then I will answer it. What is the practice in the U.S. for claiming a priority of design based on a previously filed patent, e.g. in the drawings? So, in the United States, because designs are a form of patent, we are able to, and regularly do, file a design patent that is a continuation of a prior utility patent. This does happen pretty regularly. I'll tell you there are some important things to know, which is that generally speaking, the utility patent needs to still be pending in order to file a continuation. And so it is theoretically possible after the patent has issued to put the utility patent back into examination and then file a continuation, but that's an extremely expensive thing to do. Most people just file a design off, if they want to, off of a pending utility application. Some important things to note are that this is sometimes challenging because if the utility application, a lot of times utility applications include sort of theoretical or notional drawings of something. They don't include drawings that may meet the definiteness and sort of, they don't include drawings that show enough sides of the object typically, or that those drawings are actually consistent with one another. So something that you see applicants do sometimes, which is a little bit unfortunate, is just sort of throw the utility drawings into a design application and file them. And at least in the United States, that's often not going to work out real well, because you often have problems with the designs not being consistent. Another gotcha that I see that gets people is they sometimes want to try to claim priority back to a utility application that was filed in another country. Now, under U.S. law, you can do that. However, the foreign utility application and the U.S. utility application need to have been filed within 6 months of each other in order to maintain the priority chain for the design. So a lot of times, again, we see that this wasn't what people thought about ahead of time, and so they just filed their utility or U.S. utility within a year of their foreign utility, because that's what you have to do under Paris Convention for a utility patent. And then they sometimes find that their design priority claim hasn't gone as far back as it was supposed to. I hope that's helpful. Okay, so one other question that we have, and keep those questions coming, guys, but one other question we have is, does anyone, and this is sort of a round table, go around to each person in the group, are there any updates that you can share about user interface design protection? So, Alexandra, do you want to start us off with that? Have there been any additional cases involving user interfaces?
Not really, actually.
Would you say it's a particular area in Korea for people to file UIs?
If it's what? I didn't hear you. Sorry.
Popular area. Like, are people filing a lot of user interfaces?
Yes. There's a lot of filings for DUIs in Korea.
Yeah, I think what we've seen in the United States is there's a lot of filings, but there haven't been as many enforcement actions. So we don't have as much case law on user interfaces as we might like.
Yeah, there's not any recent decision on this. So I guess it's similar to the situation in the US.
Tomohiro, do you have any information about anything changing in the user interface area in Japan?
Well, there are no recent infringement cases relating to GUIs in Japan. But as you might know, the design law was largely revised in 2020, and the protection of GUI became very wider. And currently, we can register GUIs alone, so independently of articles. So many applicants are interested in filing GUI applications, and I think the number of GUI applications has been increased in Japan. So that's a current trend. Yeah.
Okay, great. Guanyang, what's the situation in China?
You mean the situation in for graphic user interface in China?
Yes.
Yeah, I think there's more and more GUI applications in China, and so actually in my slide, maybe I can. Yes, can I move to the slide? So
sure. Is it this one right here?
Yeah. So okay, that's fine. Yeah. So actually, for the GUI filings, there are more and more GUI filings in China, and we believe that should be a trend for the patentee or the designer to enforce such GUI GUI patents in China, because as I have mentioned, Shanghai courts have issued a judgment which are very favorable to the GUI designers. So that maybe in the future, so because GUI are more and more applied in the apps in the phones, so there should be more and more patent enforcement actions in China, we believe, to be launched based on the GUI design patents. And also the damages for such GUI patents are also, we believe that should be okay, maybe $100,000 US. So we think that should be okay damage in China.
Okay, well, that's really helpful. Yeah, what I would say in the U.S. is that we continue to have a strong GUI filings. There's, we've heard from the Patent Office somewhat anecdotally that that GUI represents the largest growing area of designs at the Patent Office, and that they are regularly adding more examiners to examine GUIs. So I think we see that. We did have a series of GUI cases involving a banking mobile app, but that was kind of interesting in that there was some question as to the validity of the design patent that was asserted, and actually a number of the folks that were, or companies that were sued, went back to the Patent Office to challenge the validity of it. And although some of those are still going on, it seems like the patent owner is not really participating in those cases anymore. But I think what that says is that as different as people think GUIs are, in a lot of ways they are still treated just like other designs. There's not as much sort of specialness to them as maybe people thought in the past. Okay, I think we have time for one more question. And this one is, has any of your clients taken advantage of using the Hague system to file, oh, sorry. I was going to answer this other one first. Does enforcement of the Hague applications differ from a classical design patent, especially in view of the fact that Hague applications seem to be more of a registration system? So I'll answer the second part first, which is that a Hague application is a registration system in countries that have registration systems. But in countries that have examination systems, a Hague application is examined similarly to a sort of homegrown application. So in terms of enforcement, you know, I think that I'd be curious to see if any of the other speakers have any thoughts on this, but I have seen occasionally that some things get out of the Patent Office that are a little bit odd in Hague applications. I don't know that I've seen a Hague application actually enforced in court, at least not that I knew of when I saw it. But I have seen some things that are a little bit odd, and I have wondered whether or not, I wondered what a court would do with those applications if asked to consider it. And I'm curious if anyone else has had that experience where they've seen a Hague application come through that does look a little bit different than their original, you know, sort of first filed in their country application. Has anyone else had that experience and seen that and wondered about that? Okay, well, I guess maybe I'm the only one wondering that, and that's okay. All righty, well, that is that takes us to the end of our time today. If we didn't get to your question, don't worry. We have copies of all the questions, and we will get back to you by email. But we very much appreciate your attentive listening today. And again, you will receive a link to this webinar so that you can share it with colleagues or watch it again if you'd like to. And I again want to thank all of my co-authors for their generous time today in updating us on what's going on in their countries. So I hope that you have a productive what I believe is now Thursday in Asia. And thank you all for attending.